Google's been declared a monopoly by the courts. Now what? Everything you need to know about the Google antitrust lawsuit.
Back in the 90s, before there were cars and there were still children working in the factories, the Sherman Antitrust Act of 1890 was passed by the U.S. Congress. This law was designed to go after the big industrial monopolies, such as American Tobacco, Standard Oil, and the likes.
The purpose of the antitrust legislation was to prevent monopolies from taking complete control over the market. A monopoly is defined as a single seller of goods, but it's a little more complicated than that. There are two types of monopolies: vertically integrated monopolies that control everything from resource extraction to refining to manufacturing to the final sale to the consumer. Then there are horizontal monopolies. They control wide swaths of the market in every which way that a consumer could try to buy something and all the things related to it. But basically, the point of a monopoly from an economic perspective is to maximize profit while minimizing costs. Monopolies are able to control the supply artificially, thereby reducing the amount of supply available to consumers, but maintaining the profit levels they would have been able to achieve if there were multiple sellers and they were selling more goods in a competitive market. This is called rent seeking. Long story short, because monopolies artificially restrict the supply, the theory is that by breaking up monopolies, you're going to increase the amount of goods that are available to consumers and lower the price that the consumers pay. But enough of this econ talk, let's get back to the law. The Sherman Antitrust Act allows the US government to sue companies that they accuse of being a monopoly. And by suing, they're able to correct the market to prevent the monopolists from having the amount of control that they currently exert. The Sherman Antitrust Act has two main sections. Section 1 prohibits anti-competitive contracting, basically prevents the collusion between a few companies to artificially control the supply of a good. Section 2 prohibits an actual monopoly from abusing the economic power that they hold in that market. Section 1 goes after anti-competitive collusion. Section 2 goes after monopolies directly. A violation of Section 2 of the Sherman Antitrust Act has two elements. One, that a company has a monopoly over a specific market, and two, the willful acquisition or maintenance of that power as distinguished from growth or development as a consequence of a superior product, business acumen, or historic accident. The regulation of monopolies has a 130-year history, but it's mainly been used against big industry. However, with the dawn of the information age and the internet, monopolies have begun to form in new ways. There's been a renewed focus on breaking up big tech firms. The most famous application of the Sherman Antitrust Act relates to Microsoft back in 2001. Microsoft was accused of monopolizing the market for internet browsers by making it difficult for people who built computers and for users to uninstall Internet Explorer and to use other browsers on their operating system. At trial, Microsoft was found to be in violation of Section 2 of the Sherman Antitrust Act. This finding, however, was partially overturned on appeal. Initially, the government was threatening to break up Microsoft, but later it dropped it down to a less severe penalty. Eventually, though, before the penalties were imposed, Microsoft and the government entered into a settlement wherein Microsoft really promised to change its bad business practices. Now to the case at bar against Google. Google, really its parent company Alphabet, owns a huge swath of the internet. Obviously, the Google search engine is the big one. However, Alphabet owns YouTube, Gmail, Google Drive, and tons of other facets of the internet. Lots of people like the Google search function because it's free and it is pretty good, although I would argue that it's declined significantly in recent years by manipulating search results. Moreover, people like the free features of the Google search engine, but in reality, they're not really free. Google collects a ton of information on you and uses it in order to predict your behavior and to drive advertising. Remember, folks, if it's free, you're for sale. Specifically, the government has accused Google of monopolizing the search function and text-based advertising, those Google ads that you see. Let's work through the elements. In terms of search, Google has 83% of all desktop-based searches and 95% of all mobile-based searches. As for text-based advertising, Google controls 88% of the market. Element 1? Check. As for Section 2, Google pays other companies such as Mozilla, Apple, and a bunch of mobile providers such as AT&T, Verizon, etc. to ensure that their consumers only have access to the Google search function. Element 2? Check. On August 5th, a trial court found that Google was in fact acting as a monopoly in violation of Section 2 of the Sherman Antitrust Act. So, what happens now? Well, first off, Google is definitely going to appeal this ruling. And so there's going to be a lot of legal wrangling in the months and potentially years to come in the appeals courts. Google's going to say that they're so dominant in the market because their product is the best. And that's okay so long as they aren't violating the second element of the Sherman Antitrust Act. They're also going to say that their text advertising dominance is based on the fact that their search engine is so popular. It is possible that the appeals court may overturn one or both of the findings. As for element 2, however, the use of their power in the market for anti-competitive ends, it's less likely that that's going to be overturned on appeal. But for the sake of argument, let's just assume that Google loses all of these appeals. Google could be forced to sell off facets of its business. And so different companies would own the Google search function, the Google text-based advertising function, YouTube, etc. The government could also try to break up the specific functions, such as the search function, maybe into text-based searches, image-based searches, etc., but that seems a lot less feasible. The government could also invalidate the contracts that Google has signed with companies like Mozilla, Apple, and the mobile carriers, and prevent Google from entering into such coercive contracts in the future. Another potential solution is that Google's forced to pay a gigantic fine. What's the most likely outcome? Well, given the fact that America has the best government money can buy, I don't see any severe punitive action being taken against Google. I don't think they're going to break Google up, although they might force them to sell something like YouTube. But Google's going to argue that this is going to hurt consumers because the overwhelming profitability of their search and text-based advertising allows them to offer services like YouTube and Gmail for free. If anything, I'm expecting a redo of the Microsoft case, wherein Google's just going to promise that they'll never ever engage in such horrible business practices again. They promise to be good this time. It's also possible that Google will be forced to pay a gigantic fine, but I really doubt that Google's going to be broken up into a bunch of smaller companies because, well, it's
got to be the king.
Thanks for watching, and as always, be sure to like, subscribe, and click that little notification bell so you never miss an important legal update. Thanks.